Hello, welcome. This is the part 2 of our discussion on wills and letter of administration. We have earlier in the part 1 discussed wills. Today we'll be discussing the letter of administration. Follow me, let's go on to the discussion. Click on the subscribe button, like this video, share with your friends, and drop your comments or questions on the comment box. Thank you. Now we'll look at the letter of administration. Now, where a person dies without writing a will, in law it is said he died intestate. He died intestate, meaning he died without leaving a will. How can his property be shared? Who will take care of his property? That is where now a letter of administration is needed. A letter of administration is a letter, it's a power given by the court to certain persons who will act as administrators or administratrix. That is, for the female, they are called administratrix. For the male, it's called an administrator. A letter of administration is what is given to them, which is now the power for them to administer the estate of the deceased person for or on behalf of the beneficiaries of that estate. Now, a letter of administration does not confer ownership to the administrators, no. And we should understand that an administrator or an administratrix most times are not beneficiaries. Once you are made an administrator, that does not confer or that does not give you the power to be a beneficiary of the deceased estate. Yours is to just take care of the property. For example, if the beneficiaries are minor, when we say minor, we mean persons under the age, persons that are not recognized by law to take charge or take care of properties. You can be an administrator to guide, to hold the property for them, pending when they are of age, so that they can take charge of their properties. Or on the alternative, where a person died intestate and is having already grown-up children that are of age, then one of them can be made an administrator for the purpose of collating and taking charge of the whole property, that the law now will hand over the property to him, so that the whole administrative rigors will be done by him on behalf of the other beneficiaries. That is when an administrator or an administratrix can be a beneficiary. But other than that, no. Once a person dies intestate, the family can meet a lawyer to go to the same probate division and apply for a letter of administration to be issued to whoever they appoint as an administrator or administratrix to keep or take charge of the properties left by the deceased. Now, once a letter of administration is being given, the whole property or the whole estate of the deceased will be itemized in that letter of administration. For example, if he's having shares in a company, it will be registered there. If he's having money in a bank account, it will be there. If he's having properties, wherever they are, those things will be itemized in the letter of administration for ease of devolution to the beneficiaries. Now, once that letter of administration is given, then the property now can be shared to the beneficiaries in a way they agree it should be shared, since the deceased has not stated how he wants it to be. So it is there and then they can agree within themselves on who takes what and what goes to who and what happens. Without a letter of administration, there is no way, there is no how any other person can administer the property of the deceased. It is just these two ways. It is either through a will, where we say the person died tested, or through a letter of administration, where we say a person dies intestate, that his property can be shared to the beneficiary. However, but if the deceased who dies is a Muslim. In the Islamic law, there is law of mirath and wasiya, which governs the sharing of inheritance or properties of a deceased person who died intestate. The Islamic law has its own way of sharing properties to the beneficiaries if the deceased died intestate. Also, where the deceased is a believer of his customs and tradition, if the custom and tradition gives a way and manner which the properties can be shared, then that custom and traditions will prevail. But it must be noted that the custom and tradition must not go contrary to good conscience, equity, and natural justice. If it is like that, then it will be taken off. The tradition and customs must not be obnoxious. Otherwise, it is the letter of administration or the will that will govern the estate of the deceased. However, some persons do make mistake and want to give beneficiary or wants to give an administrator powers that he doesn't have, which is to say an administrator is now a beneficiary. No, it is not so. We must get this act straight. Once it is a will or a person dies intestate with a will, then definitely property will be shared in the way he states it there, black and white. If it is intestate, then the letter of administration must be gotten before now anything can be done with that property. We must understand that once a person is made an administrator, he must report to the court every 6 months of the state of affairs of the properties. That is to say, he must regularly, after every 6 months, go back to the court and say, so and properties, and so properties that have been given to me, all of them are intact. Or I have the consent of the beneficiaries to sell so and so properties, which we have sold, and this is what they use the money for. Whatever is done, he must come back and report to the court. Otherwise, he will be held liable. Anything that happens to the property. It is a duty on the administrator to be very careful once properties are handed over to him. It is not for him or her to do anything he wants to do with those properties. No, he must be accountable. And if at the end of the day, an administrator is handing over the properties to the beneficiaries, he must come back to the probate division and bring everything and bring the record of everything that has been handed over to him or her, so that an account will be taken of everything. And if it is intact, he will or she will be discharged, and the letter of administration will be taken from him and destroyed. But if anything is missing, even if it is a pin, that administrator or administratrix must account for it. And if he can't or she can't account, she is liable to go to prison. As an administrator or an administratrix, one should be very, very careful, and one should keep everything given to him or her intact until when he or she surrenders back to the beneficiaries. However, whatsoever expenses an administrator or administratrix incur in the process of keeping this estate, he is going to be reimbursed. He is not the father, or she is not the father Christmas. Definitely any expenses incurred, definitely he's going to be reimbursed. And understand that paying the administrator or administratrix is going to be from the estate that is left by the deceased. Don't get mad. Just get a lawyer to help you with all these rigors. Click on the subscribe button, like this video, share with your friends, and drop your comment on the comment section. Thank you.